Welcome to Senate reform in the 21st century. I think some of us thought Senate reform was a 20th century phenomenon, but not so. And so my name is Pat Parody. I'm the Executive Director of the Center for Constitutional Studies here at the Faculty of Law, and we are very pleased to be co-sponsoring this event with International and Intergovernmental Affairs, with Government of Alberta, and with IPAC. And we have two speakers with us today, Jared Wesley and Professor Carver, both of whom are going to enlighten us about Senate reform in the 21st century. Jared will be talking about issues and debates to date, what's going on with respect to Senate reform, and Professor Carver is going to focus on the reference questions that have been put by the federal government and the Quebec government to the courts. And so, I'll just by way of brief introduction then, I think each of our speakers will speak for about 20 minutes and then we'll open the floor up to questions. So Jared Wesley is Director of Federal Provincial Relations with the Government of Alberta and an adjunct professor of political science at the University of Alberta. In his role with the government, he works to strengthen Alberta's relationships with other Canadian governments through the negotiation of intergovernmental agreements and the development of common interests. On the academic side, he is principal investigator of the SSHRC-funded Comparative Provincial Elections Project, which is studying the democratic deficit in Canada's 10 provinces. And Professor Carver has taught at the Faculty of Law for the past 12 years in the areas of Canadian constitutional, administrative, and immigration law. He was chair of the board of the Centre for the Constitutional Studies between 2010 and 2012. His most recent publication is an article titled Comparing Aboriginal and Other Duties to Consult in Canadian Law. When asked about his interest in the Senate, Professor Carver said that while he might like to be appointed, he would not consider running for election. And so, without further ado, over to you, Jared.
Well, thanks, Pat, and thank you to the Centre for organizing this event. I think we should do more to build bridges between both sides of the river when it comes to issues of politics, law, and other issues. And events like this go a long way towards creating the kind of pracademic culture and networking that I think would benefit both of us. And that's something that IPAC as well supports. So as Pat mentioned, in my role with the Government of Alberta, my title is Director of Federalism and Constitution with the Ministry of International and Intergovernmental Relations. I like to joke that I direct neither federalism nor the Constitution. They more direct me. But it is one of the responsibilities of our ministry to monitor events with regard to Senate reform. So I'll limit my discussion today to what are the sort of things that we're looking at from a political perspective, and I will defer to the constitutional lawyers in the room and constitutional law experts, and I claim to be neither. So I'd just like to walk you through a bit about Senate reform in context. A wise man once said in our office that the House of Commons is grounded in the democratic principle of representation by population. The Senate is grounded in the federal principle of regional representation, and together they help us achieve the national will. So from our perspective and perspective of most governments across Canada, the Senate still does play a valuable role in expressing the democratic interests of the country. So I'll use my 15-ish, 20 minutes to go into a little bit of background about Senate reform. I'm not going to spend too much time talking about Senate reform in the 19th and 20th centuries. I'll spend most of my time talking about it now, because for a lot of us, we haven't engaged in this subject in a real way since Charlottetown. So I'd like to bring you up to date on what's happened. Talk a little bit about the state of public opinion about Senate reform in Canada and how the current state of politics is likely to play out over the coming months. I will spend very little time talking about Senate reform in the Constitution, deferring, of course, to Peter. And then we'll talk about, again, looking forward, what are some of the key issues and debates that we anticipate engaging in the coming months and years. So, for those of you that are familiar with Senate reform, you'll recognize that most reform discussions, most reform packages have revolved around four different themes. Right? The composition of the Senate, the senators' tenure, how we select senators, and the powers of the Senate as an institution itself. You'll recognize, of course, that most recent proposals for Senate reform have not touched on all four. They've touched on one or two. But I'm here to suggest these are all interlinked elements, and changing one will have an impact on the other three. So in terms of the composition of the Senate, most of the time when we talk about Senate reform, people in Western Canada especially flash to images like this, right, where the map of Canada is heavily tilted towards certain regions, and other regions feel disproportionately represented in the federal parliament as a result. Ontario and Quebec each have 24 Senate seats by virtue of being regions unto themselves, while the Western provinces divide 24 seats amongst themselves. I should also point out on the issue of composition, for the first time in a while, the majority of senators represent the Conservative Party, and that's raised questions about why Senate reform hasn't moved as swiftly in Ottawa, but hopefully we can get into that. Some advocates for Senate reform will point to figures like this that suggest that certain provinces are underrepresented in our nation's capital on a per capita basis when we take a look at the number of senators. I'd caution against looking at Senate representation in this way, because most people, when they talk about equality in the Senate, talk about equality by province or equality by region, not equality by representation by population. That's the foundation for the lower house representation. Very few people would point to graphs like this as evidence for the need for Senate reform. It's actually quite fitting that we're here today on March 22nd, which is the 75th birthday of Bert Brown, one of Alberta's democratically selected senators, and Bert actually has to retire today by virtue of the fact that he has turned 75. By the way, no word on who may replace him. Usually the Prime Minister's office will release an announcement within weeks. Depends. They may wait for a build-up of several vacancies before they appoint en masse. But we're still waiting to see. In the meantime, we wish Bert all the best with his birthday and with his retirement. But since 1965, we're all aware senators have served until a mandatory retirement age of 75. Many people today still view this as being akin to a lifetime appointment, especially if you're appointed at a younger age. And many people are asking for senators to be selected on a regular basis and for their tenure to be limited to a certain number of year terms. When it comes to the selection of senators, along with the British House of Lords, the Canadian Senate is the only remaining upper house in Western democracies to have appointed members. Right? And a lot of people say that we should move some distance towards democratically selecting people to represent us in our federal parliament. And some provinces, like Alberta, have taken steps on their own through Alberta's Senatorial Selection Act. We have set up a process by which we select senators on behalf of Albertans to sit on a list from which we strongly recommend prime ministers appoint or recommend to the Governor General for appointment. We are the only province that does that, although other provinces, including New Brunswick, Saskatchewan, and BC, have mused about it at the time, at different times. And the last element of this of Senate reform we often hear in these packages and in discussions has to do with the powers of the Senate. And a lot of reformers have sought what they call a more effective Senate, one possessing a number of new powers that would empower senators to conduct more than simply routine business or sober second thought and committee work. Some have suggested that the Senate should have power to approve or endorse appointments to certain senior federal positions, much like the United States. But again, changing different components of whether we're talking about tenure, selection, powers, and so on, will affect the other elements of the Senate. I'm not going to go into detail here, but a lot of these four concepts have come up at different times in Canadian history. We start this particular slide in 1978, but to be honest, Senate reform has been on the agenda at different times since the 19th century. So what does the public feel about Senate reform now in the 21st century? And there actually has been some regular polling by Angus Reid in particular. They've done quarterly and sometimes half-yearly public opinion research on the issue. Harris Decima has also been active in the field, and this one's taken from a year ago. We expect them to update this now, given that we've had several reference cases. They say about 61% of Canadians are actually prepared to reopen the Constitution in order to reform or abolish the Senate. Keep in mind, when we're gauging public opinion, of course, this is an abstract this may be the only question on Senate reform in that omnibus poll. But it does suggest that many Canadians appear to be ripe for a discussion about Senate reform and even prepared to open the Constitution to do it. Of course, when we open the Constitution, confining it to one particular issue is a challenge in and of itself. February 2013, so about a month ago, Forum Research released a poll and was asking Canadians how they feel about an elected Senate, abolition of the Senate, or status quo. And again, a vast majority of Canadians are prepared to change it in some way, whether that's by electing senators or by abolishing it altogether. And if you take a look at the breakdown across different regions, we find that election is popular in a lot of provinces, most popular here in Alberta, given that we have a process that seems to be working quite well for us, at least under the current federal government. Abolition, more popular in some regions than others. And just as this is a political scientist in me, I apologize, but just to show you that this division actually breaks down across a bunch of different variables as well, including income. So it's not as if we're seeing other variables affecting this. Most Canadians are prepared to change the Senate in one way or another. So how has this set up the current state of play for as far as the politics of Senate reform? Well, we know that the federal government has proposed several different bills, I believe eight different separate pieces of legislation since they came in 2006 or thereabouts. The most recent version of it comes in the form of Bill C-7, the Senate Reform Act, and it was first read in June of 2011. And the federal government in that bill is seeking to change two aspects of the Senate. First of all, tenure. They have suggested a 9-year non-renewable terms for senators, and that's changed throughout the course of this particular government. They originally started off with proposals to have 8-year terms and it be renewable, so they've played around with that, but now they've landed on 9-year non-renewable terms. And then in terms of selecting senators, the Prime Minister may select from provincial lists, with the process being guided by what's called a voluntary framework that provinces could follow to select members to those lists, from which the Prime Minister would then select and recommend to the Governor General for appointment to the Senate. A lot of people have questioned what's the game plan behind the federal government's approach, and your guess is as good as mine. And many media commentators and other governments have their own theories. Some suggest that this is part of an incremental strategy by the federal government or creative destruction strategy, whereby they would pursue non-constitutional renewal in piecemeal form and set up a situation where the rest of the dominoes must fall as a result. If we're going to have elected senators, that means we must engage in a discussion about how the Senate, what kind of new powers the Senate's going to have, and how we're going to break deadlocks between the Senate and the House of Commons. Right? So they see this as this is Bill C-7 and bills like it as step one in a two-step process. The second one being a micro-constitutional reform that would address those other elements of Senate reform. Others suggest that the federal government is engaging in a nuclear strategy to set up a situation where Senate reform appears impossible, and therefore we may as well abolish the thing altogether. That is a minority opinion, but those are some of the theories that exist out there for what the federal government is doing. Where do other provinces and territories and different political parties stand? Well, there's an abolitionist camp, those that seem to be in favor of abolishing the Senate altogether. Ontario, Nova Scotia, Manitoba, and at times Saskatchewan have been in this particular camp. Although Manitoba, Saskatchewan, and BC have said that they're prepared to reform as well. So they're kind of on the fence, reform if necessary or abolition if necessary, depending on the week you catch their premium. Right? The federal New Democrats and Bloc Québécois are also firmly in the abolition camp. Committed reformers include Alberta and New Brunswick and the Federal Conservative Party, and Quebec, Newfoundland, and PEI and the Federal Liberal Party seem to be somewhere in the middle. We're not quite sure where they stand, but no one is really happy with the way that the Senate is functioning now. We all just disagree on how to go about changing it. I'm going to defer, of course, part of the state of play is the reference cases that Peter will go into greater detail in a moment, one before the Quebec Superior Court and one before the Supreme Court of Canada. And of course, now this other piece that's come into the discussion about the Senate are the various expense scandals and residency scandals that have surrounded senators like Senator Duffy and so on. So that's kind of framing the debate and will really play a big role in shifting public opinion, we believe, in the coming months. So the big question that's before a lot of provincial governments, territorial governments right now is how can Senate reform be achieved? What are the particular constitutional and non-constitutional routes we can pursue? There are several questions within that general area. The first set of questions are, do the Harper government's proposed reforms in C7 actually constitute fundamental changes to the powers and composition of the Senate? If they don't, then maybe they can either be pursued through unilateral federal amendments, or they may be pursued through non-constitutional means. Is the federal government, secondly, is the federal government doing an end run around the Constitution, knowing full well that they're intending to change the way that we select senators, but is using language that suggests that it's only voluntary and the framework does not bind the Crown in any particular way? Those of the constitutional lawyers in the room may recognize the term colorability to refer to that particular approach. You cannot do things non-constitutionally when you can't accomplish them constitutionally. It's an old premise or an old convention in law. Thirdly, do the conventions surrounding constitutional amendments that were established prior to 1982 actually serve as precedent for reforms today? This is the first real challenge of fundamental elements of Canadian parliamentary institutions with the new amending formula. So there's all kinds of questions as to whether the upper house reference, for example, applies to this particular situation, or whether we're in a whole new constitutional law ballgame. And lastly, what's the constitutional and political status of the federal government's regional vetoes legislation? I'm surprised that media is not picking this up, but remember, as part of Plan B in the aftermath of the Quebec referendum in 1995, the federal government under Prime Minister Chrétien passed a piece of legislation that said that Parliament will not endorse constitutional amendments unless all of the regions were in favor of them. So it's actually layered on a new set of rules concerning constitutional amendment. And so Quebec has to be on side, Ontario has to be on side. Two of the four Atlantic provinces have to be on side. I think it's 2 of the 3 prairie provinces with half the population have to be on side, and so on. And that really binds the federal government in terms of what it can do with constitutional amendments under its own authority, unless it repeals that legislation. I can go into greater detail on that in the question and answer period if you'd like. So some of the key issues in debate that are going on right now, just to close up. Arguments on the federal government side when it comes to tenure, constitutional amendment, they say is possible using the parliament-only formula. In other words, they don't need to consult the provinces when it comes to changing the tenure of senators away from a 75-year to a fixed term. In 1965, they argue the federal government unilaterally established a mandatory retirement age of 75 without consulting the provinces, and as a result, that authority should apply to today, regardless of the fact that we have a new amending formula that's been put in place since. The opponents to this particular approach suggest that the constitutional amendment must use at least the 750 rule, and that a change in tenure actually is a fundamental reform to the Senate, and therefore some argue might actually trip the unanimity requirements under the amending formula. When it comes to the selection of senators, the federal government argues that they can change it the way that they want to with that voluntary framework, requiring only federal legislation and not actually a constitutional amendment, because they argue the Crown's prerogative is maintained and the Prime Minister still has choice among the nominees that the provinces may put forward. Opponents argue that this actually does require constitutional amendment, again using the 750 or general formula, that binding or not, these public consultations actually do constitute a new method of selecting senators, and that this informal practice may actually become constitutional convention, and that the federal government is doing an end run around the Constitution and committing the sin of colorability. Lastly, when it comes to abolition, recent appointments and actions, including those scandals, have raised the question about the undemocratic nature of the Senate. And removing the Senate, some argue, would enhance the power of provincial governments as the strongest voices of regional interests. Those that favor keeping the Senate suggest that abolition would require a constitutional amendment and unanimity would be required, therefore it's impossible. Well, I hope we can get into a discussion about whether it actually is impossible. And lastly, that Parliament actually does need that type of regional representation in order to carry on the business of the nation. There are other issues that are dealing with the 30-year age minimum or the $4,000 property requirement. Those have actually been built into some of the Senate references itself, and I'll defer those particular questions to Peter as well. So hopefully that's giving you an overview of where we've come in terms of Senate reform and where we are now. And we, like every other province and territory in the country, are watching closely, studying carefully. We've all applied to intervene in the Supreme Court of Canada's case. We all get our 10 minutes. There will have to be, I'd imagine there will be, among our lawyers, some coordination on who will speak to what. But we are watching as carefully and with as much interest as you folks are to see what transpires over the next couple of years. So with that, I'll turn it over to back to Pat or over to Peter directly. I'll turn it right over to Peter.
Thanks very much. I think Jared's presentation, I hesitate to speak after that and to launch into what's a bit more of a legal analysis because I think Jared has covered a lot of the groundwork and laid it out at a very nice level for if a discussion was to start right now. But I am scheduled to speak, so I'm going to go ahead and do it, and hopefully it will contribute to what we have time for by way of questions and discussion after that. Okay, well, the poster for today's talk is titled Senate Reform in the 21st Century. And as many of you know, this law school is engaged in a celebration of its 100th anniversary, and it occurred to me that if I did some research, and I have not, I might well find that in 1913, in its first year of existence, the law school had a session on Senate reform in the 20th century. And with lots of exciting ideas and a sense of that maybe we could go this way and that way and so forth and so on. And then the survivors from that panel, should they turn up, say have turned up or still be around the law school in 2000, might have come back or had a coffee session and discussed, well, you know what? They now have to retire at age 75 as sort of the conclusion of their dreams for the 20th century. So we're early in the 21st, and I think we can ask or wonder whether we're going to see a lot of change with respect to the Senate and how we might get there. And that's, of course, what we're talking about today, and in some ways what is before us. Now, I've given a different title to my little talk in that I thought, well, I'm talking about the references right now and the legal matters that are before the courts. And as one way of summarizing the question before the courts, I chose the title, Whose Senate Is It Anyway? Thematically connecting to the references, but what I want to suggest right off the top is that I think there is a very pleasant, politically correct, you could say namby-pamby, I don't know what, maybe, but I've just said it, way of answering that question and say, well, the Senate belongs to the people of Canada, and they should get what they want, and what they want, and we can test through public opinion and so forth and so on, and that's, it belongs to us, the people. But I want to answer this in terms of constitutional law and politics, a hard-nosed area that we study and hear, and that is of interest to those of us who do that. And the answer to the question is in the traditional Canadian fashion, and in these references, the question in some sense can be boiled down to who does the Senate belong to, the federal government or the provinces? And if it's some kind of joint ownership, then how is that to be split up and get to some movement on reform? Okay, well, I'm going to talk about, if I can, move through four things in the talk. First of all, what's the proposal that the federal government has put forward in Bill C-7? Secondly, what are the reference questions and the state of the references before the two courts at the moment? Third, just a very little bit on what I anticipate the legal arguments may be by the two main parties at this point. And lastly, I want to talk about the position that the Supreme Court of Canada may see itself in with respect to these questions and how it might view itself, as it sometimes I think does, appropriately in my view, as engaged in constitutional politics as well as constitutional law. So now I have to see if I've got the right button here. The red button? The right one. Okay, that's it. Okay, so the proposal, this is Bill C-7. These are the two principal sections in Bill C-7, which is a very brief statutory proposal made by, put before Parliament over a year and a half ago. And the two main features, as you can see, first of all, in which one? Section 3 goes to the selection of senators, and as Jared indicates, establishes by statute, and this is the only statement that is proposed to be made, I'll qualify that in a moment, but it invites provinces to engage in a process of elections held in the provinces to come up with lists of nominees, and then it binds the Prime Minister to base his or her recommendations to the Governor General, who has, under our Constitution, the lawful authority to summon individuals to the Senate. Now, there are various, in studying this over the last few days, there's a lot of very interesting stuff in this whole situation, legally and politically. But for one thing, this is referring to the role of the Prime Minister. Well, that's a conventional role. Nothing else refers to the role of the Prime Minister in the Constitution. But this is saying that in serving his or her conventional role of giving names to the Governor General who must act on those recommendations, the Prime Minister will be statutorily bound, or to consider, not to use the names, but to consider those names in making recommendations. Okay, so that's the proposal. Now that involves and their proposal suggests no changes to constitutional text. It's only a statutory statement in an act of Parliament. Now the second proposal does involve a change to constitutional text in Section 29, and it would involve replacing the current language about mandatory retirement at age 75 to a statement limiting the service in the Senate to a term of 9 years. Otherwise, the provisions in the Constitution, the text of the Constitution, all remain unchanged about the role of the Governor General, the qualifications for Senate appointment, and so forth. Okay, so that's the proposal. There are other things. The other interesting thing in terms of Section 3 and the selection of senators is that the statute sets out a schedule that establishes the process of elections that would be held in the provinces that agree to this formula and to engage in an election process for coming up with nominees to go forward to the federal government for appointment. And it's essentially tracking, in most respects, a kind of a Canada Elections Act formula for holding elections. And another of the interesting smaller questions is the authority of Parliament to establish the electoral format for what is essentially a provincial election. But that I'm not otherwise going to say anything much about that. Okay, so that's the proposal. Now I want to talk about the references. So a few words about references to the courts and what they are. First of all, you will note the plural. We have two references going on that bill. One was launched by the government of Quebec, and it was the Liberal government of Premier Jean Charest before their defeat in the most recent Quebec election, which launched a reference to challenge Bill C-7 before Quebec's Court of Appeal, which is a statutory power that the government of Quebec, like all other provincial governments, has, to refer questions such as constitutional questions to its highest court, its Court of Appeal. So that was launched a year and a half ago, not long after Bill C-7 was introduced, indicating Quebec's displeasure with the proposal. Now, only within the last 2 months has the federal government moved to initiate its reference to the Supreme Court of Canada, which is its statutory power it has. And I think we must see that, and the actions around it would clearly indicate this, that this was an effort to preempt the Quebec court reference. And the government of Canada has tried to get the Quebec court to drop its reference. The Quebec court has refused to do so. So we have what I think is, I don't know if it's unprecedented, maybe some of you can tell me, but I'm not aware of any other situation that so clearly involves a competitive race to reference answers by two courts where the governments are asking different questions, only want their court, or at least want their court to give an answer maybe before or at least in the midst of giving answers, and then work to a conclusion on that. Now, the Securities Act in some ways was, and we could maybe, I know there was some competition in that one too about who would deal with it. In the end, that worked out in a somewhat orderly fashion. This one probably will, because I imagine the courts want to be orderly. But at the moment, it's a bit of an impending train wreck. The Supreme Court of Canada has agreed to expedite its hearing and has set 3 days in November of this year, the middle of November, to hear the federal government's reference questions. The Quebec Court of Appeal has just set on 2 days for hearings in September, 2 months before, September 10th and 11th. And I would understand, but I mean, whether they can do it and how, but I think the idea is the Quebec court wants to hear the case and get a decision or its opinion, advisory opinion, out before the Supreme Court of Canada's hearing takes place 2 months later in the middle of November. I'm not sure courts like to be they never like to be under time pressures, do they? Anyway, there's going to be some time pressure on the Quebec court if that's to occur. So, now, I don't know if I need to say much about references to this audience, but references are a recourse whereby governments can ask for advisory opinions from the highest courts generally on constitutional matters, but not solely that. And it's been understood, always understood, that the questions don't arise or don't necessarily arise out of live legal disputes, but can be based on hypotheticals, proposed legislation, and so forth. So, at that level, there's perhaps nothing odd about the process of seeking references in this regard. Now, I want to look at the questions that are being asked by each government, because each government is asking different questions. And I can't give you all the questions. Well, I can. I could have a handout. Canada is asking 6 detailed questions and talk about hypothetical. They are asking about the constitutionality of their bill, but they're asking also, among other things, about the constitutionality of former proposals, bills, that are no longer before Parliament, as that Jared made reference to. They are asking about, well, what about, how would Parliament go about, or how would Canada go about abolishing the Senate, which is not a proposal? Can we change the property qualifications for senators as Parliament, although we're not trying to do that right now? And as you can, so those are questions that are not part of the legislative proposal. These are questions that do go to the proposal they've made. And as you can see on the term limit question, they've given the Supreme Court a menu of options. And the question would seem to be not which one of these is constitutional, but select off this list any you believe would be okay. So A through G, 8 years, 10 years, this kind of limit, that kind of limit. I mean, in my experience, that's pretty unusual as a set of options. And then we have the second question on the selection election process. Okay, now Quebec's questions asked a year and a half ago, I would say are a little bit more of the kind of style we're used to. And this is the third question that Quebec is asking. And I highlight this because I think it most raises the difference that these questions represent between the thinking of the two governments. This question, there's the first question dealing with, is the federal proposal changing the office of the Governor General? That may be interesting too. I have nothing to say about that. This one, third one, I find interesting because of the underlying phrase, my underlining. What that question, and Jared referred to this as well, is that Quebec is asking whether the federal proposal is effectively amending the Constitution with respect to the Senate in its fundamental features and the role of the Senate. What that's referring to, here we have Quebec referring to precedent, to the 1980 reference on the Senate. And they are invoking that precedent as part of their constitutional argument. You don't see that kind of statement in the questions asked by the Government of Canada, which go largely to its purported unilateral authority under the amending formula. Now, that's what I want to turn to now. I think there are interesting questions about what might the Supreme Court of Canada do with the questions. They do assert an authority, have in the past, an authority to exercise discretion within their judicial role with respect to what reference questions they might refuse to answer, and one can speculate on that. I think they might come up with a new ground never before used by the Supreme Court, which is mental exhaustion. We've answered 7 of your questions, but the last 18, we're too tired. We can't get to it. Okay, the amending formula then. And what I want to talk about then is the legal arguments, very briefly. And here I want to talk in 3 respects, in a sense, to move to the end of my presentation. First of all, I want to talk about legal arguments that I think are the ones that Canada, the Government of Canada, is most interested in pursuing and having the court deal with. Then I want to say, again, return to what I think Quebec has in mind. And then lastly, what the court may think of that, the arguments and its position. Okay, so Canada is relying on, in many ways, on the amending formula as it relates to the Senate in the Constitution currently. And they are relying most, if you will, on Section 44 in the Constitution Act 1982, which makes it a matter of unilateral power of Parliament to amend what's called amend the Constitution of Canada in relation to the government and Senate and House of Commons. And they're saying, there it is. There's our constitutional authority. Now, Section 44 exempts from that unilateral authority the matters set out in Section 42. And the main feature there is, for our purposes, is subsection B. It exempts amendments to the powers of the Senate and the method of selecting senators. So on the text of the Constitution, which is where I think the Government of Canada essentially wants this reference dealt with is the question of how do you interpret these two provisions, what do those exemptions represent, and does the proposal in Bill C-7 speak to the powers of the Senate and the method of selecting senators. And as usual in law, you can have a narrow approach to interpretation or a broader approach to interpretation. I think the Government of Canada, I would suggest, wants a narrow interpretation that says that the term limits that they are proposing, neither the term limits nor the voluntary, non-binding in law form of electing senators touch on or enter into the area of changing the powers of the Senate or the method of selecting senators. The election is just to get a list of nominees. The process remains that of federal appointment by the Prime Minister by convention to the Governor General, just using the process to get lists of nominees. Similarly, but a broader reading, I think, and the one that in fact, de facto, is what the Government of Canada, I think, is pursuing, is that this is a means to ultimately move to an elected Senate, and which is very much going to the method of selecting senators. So a narrow reading, a broad reading about what that means. Powers of the Senate. A narrow reading of that phrase, I think, would go to, well, what are the powers the Senate has now in terms of being part of Parliament, the second house, approving legislation. If it doesn't approve, if it votes it down, the legislation is defeated, et cetera, et cetera. That is the power, the powers, a major part of it, of the Senate. A broader reading of that would say the word powers doesn't just mean that. It goes to, if you will, the power of the Senate. And term limits combined with elections is going to make senators much more powerful through the legitimacy that they may well acquire by being elected and being elected politicians. And then they will have the authority as such, roughly equivalent to the House of Commons, and they the Senate may well become the powerful institution it has never been understood to be, so long as it's been a House of appointees. Okay, so that's a little bit about the text that I think Canada wants to focus on. We've got Section 44, read the exemptions or the statements in 42 narrowly, not broadly. Quebec, as I've suggested, I think wants to rely more on precedent. And I think that's what their third question, as I say, is going to. This is not, as you likely know, the first Senate reference that has asked about Senate reform proposals. There was one 30 years ago as a result of proposals put forward by the Trudeau government of the day. And the Supreme Court of Canada, in that reference in 1980, said some quite strong statements to go into the fact that the federal government did not have unilateral power to amend what it termed fundamental features and essential characteristics of the Senate. And you can see in this last quote, that there they intended by that a partially elected body, as was being proposed. That would be a fundamental feature. And there was also reference to changing the terms, like something like term limits, and that appointment for life, or at least until 75, was a limiting feature or an important feature of the structure of the Senate. And what the court, I think most importantly, did in the 1980 reference is they talked at some length, but not the length that courts these days talk, 30 years ago, but at some length about the origins of the Senate and the deal that was made in the 1860s, and how important that deal was to Quebec and the Maritimes. That the Senate was part of Parliament, but it had regional representation, and it was key to those regions or provinces agreeing to enter Confederation. The court's acknowledgement, in a sense, that you can't play with the Senate and consider it merely a federal institution owned by the Government of Canada, it also importantly represents provincial interests and is to some degree owned or co-owned by the provinces. And I think clearly that's what Quebec's, I assume that their thrust in opposing this proposal is going to. So in a sense, you have the Government of Quebec now, a separatist government, arguing from precedent and history around Canadian Confederation. You have the Government of Canada somewhat arguing, oh, let's change this stuff. Let's do it kind of informally. And let's not get too bogged down in all that historical stuff. I'm not saying that that's, of course, absolutely, that's a bit of a caricature. Okay, it comes to the court of, my last point was involved no slides, I don't think. Comes to the Supreme Court of Canada. What might they do? Well, I think, if I can say that the case that, as it comes to them, maybe with the opinion, likely with the opinion of the Quebec Court of Appeal before them, and whatever arguments have been made in this sort of mishmash of events that will occur in the fall, I think the case, in some sense, the strongest case for Quebec, if I could put it in a colloquial sense, and I have some sympathy for it, is this is no way to reform a constitution. And especially with respect to an important parliamentary institution like a country's Senate that is part of voting on its legislation, etc. This is no way to do what Canada, the Government of Canada is proposing. It's haphazard. It means some provinces will elect senators at different times to fill vacancies that come up at different points. I mean, well, what is this? And to have this done by Parliament in this way without consultation with the provinces, this is no way to amend your constitution. That's Quebec saying that. As I say, standing up for the Canadian Federation, in a sense. What's the Government of Canada's best colloquial argument? Well, it may not be a great way to amend the reform the Senate, but it's the only way. Because if we have to go through the amending formula, it's not going to happen. It's never happened. Quebec, for various reasons, is not going to be there to help reform it. Other parties to Confederation won't be either. It'll never happen. Maybe we should just abolish the thing. Or maybe, but anyway, this is the way forward, is at least if we enter into this kind of haphazard election selection process, as Jared said, the dominoes might start to fall. It might propel the governments of Canada to negotiate seriously in order to get out of the mess that this might create. So what about the Supreme Court of Canada then, faced with those two, as I put it, colloquial choices? In my limited experience, and as I say, I kind of like the fact that I view the court as often seeking to be statesperson-like with respect to these either-or choices. And I don't think they like either-or choices of that kind. I think, from a constitutional politics point of view, they'd like to split the baby, if you will. They'd like to, on the one hand, agree with this is no way to change the Constitution, and on the other hand, not leave the situation with looking like there's no hope for change. Well, how might they do that if that was operating in the background? One way is you say yes to one part of the proposal and no to the other. And although it doesn't maybe sound entirely right to me, I think they might say yes to the selection process, the introducing an element of democracy for those provinces that wish to do that, and no to the term limits. Because the term limits really, I think, are quite important to effecting a powerful elected Senate, because it means you'll have relatively regular elections happening across the country. The senators will be more like politicians. It's odd to think of electing people until they serve until the age of 75. I think it's partly why Alberta's, that this has never really gotten off the ground. I mean, it's just a, kind of an odd idea. But so by not allowing the term limits, you do sort of say, this isn't really going to be, unless it's further worked out, a more democratic legislative body and so forth. And so maybe it can. The other thing is, I think that maybe the Supreme Court might return to one of its areas of interest for various reasons, good reasons, and talk about unwritten principles of the Constitution. But the clock, means that I don't have to say anything more about that. So that's good. But I just want to end by saying I hope they don't give an answer that is essentially like no or yes, yes or no, and leave it at that, because that's not good for business, my business. I want something much more detailed than that, and much more difficult to figure out. Okay, thank you very much.
Yes, thank you to speakers. It's really opened my eye. But I need to say right now is from what I understand, the presentation is for the legal experts and law students, and I am neither. I'm just a citizen and interested. So your point, one of the points you raised is the Senate can be called one by both, the federal government as well as provincial government. To me, to non-knowledgeable person, it makes sense, because we have to send representation from each province to form the Senate. Now, I'm skeptical in the sense that if this Constitution allows the federal government to reform the Senate in the way it's advantageous to that, to the federal government, and the provinces will take care of their own affairs and interests, and as far as the law is allow them to do that, we do it beneficial to the province's government. But as a lay person, I don't know anything about law, and you're expanding the law, the term and so on. I think that the long term versus night term is almost synonymous with the tenure of professor at university, or you have to retire at 65 or 75, kind of thing. But my question now, to come to it very briefly, the other I had questions here. As a Canadian, and as only the citizen of one province, then you inform me that abolitionists can't exist. My question is, if the Senate is abolished, what really the pros and the cons for the Canadians?
What are the pros and cons?
Yes.
Well, it's a very, and you raise very, very good points. I mean, in every federation, there are two sets of mechanisms that try to incorporate or facilitate regional representation. They're what we call interstate institutions and intrastate institutions. The Senate is an example of an intrastate institution where the regions are built into the organs of the central government. And every federation in the world has some of those. Some of them are stronger than in other federations. The United States Senate, the Australian Senate, much stronger than if you're in Canada. The other set of institutions are interstate institutions, like the Council of the Federation, in days gone by, first ministers' meetings, bureaucrats dealing with each other on a government-to-government basis. Those are the strongest in Canada of any federation in the world. Right? So if you ask me what happens if we remove the Senate and abolish it, we'll be left with only those government-to-government institutions, along with a few other weaker intrastate institutions. Some say that political parties federally are actually building in regional representation through their provincial wings and through their regional caucuses and so on. But it's just removing another bulwark against interstate federalism. And we know what interstate federalism is. It's often a zero-sum dog-eat-dog game. I mean, I hope I'm not So I still have a job by the time I get back to this online. But no, but that's the way that governments interact with one another. And federations that have more national policy making, that build in regional representation, have stronger senates, have stronger other intrastate institutions, say that Canadian system of interstate federalism is actually not good for democracy. So I guess my answer to you would be, if the premiers are already very powerful, they would be even more powerful were we to abolish the Senate, because then there would be no other authoritative regional representative in the Canadian Federation.
Thank you.
I enjoyed the presentations too, thank you both. I'm going to take a little different tack here. I know the Senate is a way of getting regional representation in government. But I wonder in Canada if it doesn't play another role too, because we have the executive and legislative branches joined together. Increasingly, power is now centralized, it's equal within that in the Prime Minister's office. The Prime Minister doesn't like the Supreme Court telling him what to do. Pretty soon, we've got a dictatorship. We don't have. Do we need the Senate to be a balancing force in government? Should the proposal or things come forward that aren't in the interest of Canadians?
Well, that's a good question. It's an open empirical question as to whether the Senate fulfills that role now.
Yeah.
I mean, were we to move towards an elected Senate, some people argue, especially if they were held in conjunction with federal elections, we'd see the imposition of the federal party system just in the second house. And as a result, you probably either have, you probably would have, one party in control of both houses. At least with the Senate the way that it is now, there's a bit of a lag. So that the first few years of Harper's government, you had to cope with a liberal-dominated Senate. That said, we have seen on this very issue of Senate reform, senators hold up what is the government's plans for Senate reform, for sober second thought. So I guess for me, I'd still say it's an empirical question as to whether the Senate does fulfill that role or whether it already is largely a partisan organization as opposed to a regional representation.
I would just add, agree with, I think all of that, perhaps not add anything much to it. I mean, I think there's something odd about, and the court in 1980 and what I referred to and everything, and Quebec's position is kind of interesting as well to me, talks a lot about the regional voice in the center being quite important to the whole deal and so forth. But my sense would be, as I think you suggested, that it's not really played that role, and in any near term, it's not likely to be that regional voice in Ottawa. It's a federal body, and its greater value historically through to today has been as a form of, whether we laugh at it or not, but sober second thought, or a check, or a further review on legislative measures at the center. And so I think you're right. I agree that in a sense that's what, and if we talk about what could be lost or by abolishing, or if it was, we were to move towards abolition, I think that is the thing that would be lost, and we might gain a lot of other things by abolition, but that idea and practice might be lost. Now, on the other hand, you make the Senate more powerful through election. Jared's referred to just having two identical houses, but we also have, of course, what we like to think is maybe our better situation than the United States with respect to gridlock, and two houses that fight with each other over legislation, both of them kind of equally legitimate. So anyway, I agree with your point.
If I could just add 10 seconds to that. That's one of actually the legitimate arguments against moving to term limits and keeping lifetime or 75-year appointments, is that those senators are no longer beholden to the electorate. Now, Democrats would say, not big D Democrats themselves, but Democrats would say that makes them unaccountable. Other folks would say, no, that actually removes them from the pressures of public opinion and needing to be constantly elected, and as a result, they can't fulfill that role of sober second thought. So, I mean, these are all open and empirical, and in this case, a normative question.
Maybe we need a discussion on why we want the Senate before we start talking about how we're going to achieve that through term limits
courts are really going to get into at all the more political science type questions of, it's good for us in the public. How well is the Senate doing its job? Whatever that role originally was, balancing the regions. You'll probably find examples of where it has done that. We know it's held up legislation. And how you feel about that probably depends on how you feel about that legislation. And then there's other funny clauses around the GST legislation wasn't getting through. There's a clause that allowed Mulroney to appoint extra senators to get through that roadblock. Abortion legislation didn't get through the Senate because of some of that's kind of happenstance. The composition was such that those senators at that time didn't vote for it. So, some of this, the effects are kind of hard to predict and random, and it would be true even if it was fully elected, partly elected. We can't really get into predicting how that would turn out. So I don't know if, but I think that some of that kind of conversation might be behind what the courts might find. Like if you start reading what is impacting the power of the Senate to include term limits, then you're starting to speculate about, well, what might term limits mean? That's why I'd be reluctant to go there in terms of saying term limits would affect power, because as a citizen, I'm content that Alberta has at least some senators. Maybe it'd be best if it had more, if they had more legitimacy. But if we have term limits, we're still going to have a senator. It's just more regularly we'll be able to elect them. And even saying it'll affect the power of the Senate because then they'll be more political. Most of these people are politicians anyway. There's a few who are kind of bagmen. There was one who was a nun once. And I don't know if we're to evaluate these people differently based on that. But that's why I'm kind of reluctant to think that the court will view the notion of the power of the Senate that largely and include things like term limits or the method of selection when it's not binding.
Well, I think those are the precise questions they're going to have to engage in. I think that this is just my sense. I'm not a lawyer and I don't speak on behalf of the government here in any way, but my sense is that the court will only confine itself to those elements that affect Bill C-7. So they are going to have to engage in tenure and they're going to have to engage in selection. Whether they'll even answer questions, hypothetical questions with regard to abolition and the rest of it, in the past they have. So I guess I would say, I don't know if they're going to go down the philosophical or political science route, but those are the exact two questions that they will have to answer.
Yeah, I don't know what to say about that. I'm sure there's a line there, and I don't think they might want to get into a lot about efficacy and particular episodes. I guess if I was thinking of disciplines, I expect that they might well talk a lot about history and the origins and the evolution of the Senate as an institution, and less about political science. But I think the history and some real thinking and discussion about what is this institution, what has it been there for, what is sort of at its fundamental, what's our fundamental aspects of it. I think they will talk about that. I think they should.
I belong to the Francophone group in Edmonton, and we really value our senator, Claudette Daniel. And when I think of electing, I know that she could never have been elected. You just put a name on, and and she probably wouldn't have run anyway. And so I think we would lose a lot if we depended on people to show up to be elected. And I refused the last 2 times I voted to select somebody for the Senate. But I also wanted that I was refusing to be taken into account.
I think an intervener in the case is Franco-Canadian Association, the three, and making just that point. And it's a good point, again, in terms of election versus appointment, not, of course, just with respect to that issue, but if one is interested in a Senate having a kind of representation of different voices, which has been suggested from time to time, of course you are in many ways more likely to get that through appointment than through a general election.
Yeah, I was fortunate enough in my past life as an academic to tour around the province of Manitoba when they held public consultations on the issue of Senate reform, because they were trying to come up with an election system to try to match what Alberta was doing, but to protect different communities of interest at the same time. And it was a passionate and very well constructed argument made. It's still available on the Manitoba Government Manitoba website if you want to look it up. That made that exact argument. And in my submission to the commission, I actually got back to principles like you were saying and said it really depends on what we think the Senate should be. Do we see it as a forum or a house of provincial or regional representation? Do we see it as a body for national debate where senators go there not to act on behalf of their region, but to act on behalf of their constituency, be that Franco-Albertans or Francophones in general? Or what do we see, what representative function do we see the Senate fulfilling? And the Supreme Court in the past, you mentioned the upper house reference, has defined, at least previously, the Senate as a house of regional representation. So, I mean, you raise a very good point, and we will be seeing submissions from Francophone communities as part of the Senate.
Well, thank you. I thank you for the questions, and I guess what's wonderful about this is that we actually, get to, in a democratic way, consider these questions. I mean, we have the founding fathers who came up with their best idea as to how our government should look in 1867 and crafted this thing called the Constitution, and now we are rethinking it based on our lived experience of what it's done and has not done. So I suppose that's something to celebrate, but we wait with anticipation to see how the Supreme Court of Canada will, and the Court of